Hello, my name is Kelly Tebow. I'm with the New Jersey Center for Tourette Syndrome and Associated Disorders, and I will be your organizer for this evening. And I would like to welcome you to our webinar on IEPs and 504 plans, navigating special education. Thank you all for joining us. Before I introduce the speaker for tonight, I'm going to cover some housekeeping items with you. All participants are muted. If you have a question, please type it in the bottom of your question box and click send. You may send questions during the webinar. However, we will have Mr. Meltzer answer the questions at the end of his presentation. We will get to as many queries as time allows. In addition, tonight's presenter is available to take your questions on the Wednesday webinar blog, which is accessed from our homepage under the heading Programs. This blog will be monitored for the next 7 days. Feel free to look and post questions as often as you like. Answers will be archived. If you missed part of the presentation or would like to watch it again, an archived version of this webinar will be posted to our website. We value your input, and in order to expand the webinar experience in the future, we need everyone to fill the survey out when you exit the webinar. The New Jersey Center for Tourette Syndrome and Associated Disorders, its directors and employees assume no responsibility for the accuracy, completeness, objectivity, or usefulness of the information presented. We do not endorse any recommendation or opinion made by any member or physician, nor do we advocate for any treatment. You are responsible for your own medical decisions. Now, I'd like to introduce tonight's speaker. Andrew Meltzer is a special education attorney working with Sussan Greenwald and Wessler. Mr. Meltzer graduated from the University of Delaware with a degree in history and political science. He earned his JD from Drexel University at Thomas R. Kine School of Law. Upon the completion of his education, he was admitted to the bars of New Jersey, Pennsylvania, and the District of New Jersey. As a special education attorney, Andrew Meltzer is a classified student who conquered his learning differences, helps special needs students attain success in school and life, and they are capable through his advocacy. Mr. Meltzer knows on a deeply personal level the challenges of families and children with special needs encounter. His unique and personal and professional experiences in special education law make him a natural and effective advocate for his clients. Welcome, Andrew. We look forward to your presentation.
Thank you very much, Kelly, and it's a great pleasure to be here. So as you said, I'm a special education attorney at Sussan Greenwald and Wessler, where we work statewide throughout the state of New Jersey. And my interest in this area of law is both personal and professional. I was a student with an IEP. I had my own learning differences that I struggled with. My parents advocated very forcefully for me to get the appropriate educational program. I was able to get that, and through that help and through learning how to be my own advocate, I was able to go on through high school, college, and law school, and I'm thrilled to be practicing in this area of law. There's nothing more rewarding than paying it forward and giving back and being able to help children who have been through not always the same situation, but to be able to share some of that commonality it can't be described. So I'm going to be talking about a number of different topics tonight. Let me just make sure. Does the PowerPoint come through?
Yes, it did.
Perfect. So today's presentation is going to be on IEPs, individualized education plans, and Section 504 plans of accommodation. Just as a disclaimer, any information that I present tonight is to be informational only and is not to be construed as legal advice. If you have any personal questions about your child or anything at all, it's best to consult an attorney to find out what your rights are. So for today's presentation, as I said, we're talking about IEPs and 504 plans, what those laws are, what they require, and then what to do if you have a dispute with your school district about your child's programming. This information is applicable to both parents, students, and educators. And while I am describing how, primarily from a New Jersey perspective, how these laws are carried out, both the Individuals with Disabilities Education Act, or the IDEA, and Section 504 are federal laws. So these are laws that are present in every state around the country. Each state has their own vocabulary, or a little bit different in terms of how they carry out that law, but a lot of this information is largely, but not completely, applicable to other states. So we're first, and the other thing is I am going to be switching around to different slides. We may not be focusing on every single slide. This presentation will be shared with you and will be recorded, so you'll have the ability to come back to this. So I'm going to be giving a snapshot of all of these different areas. So first, we're going to talk about the Individuals with Disabilities Education Act. This is a federal law, and what it does is it ensures that services are provided to children with disabilities. This law was created in 1975. The reason it was created is that beforehand, school districts did not really have a responsibility to educate students with disabilities, and certainly segregated them, or often parents were saddled with the costs. That changed with the inaction of the IDEA. It provides services from ages birth through age 21 for applicable students. In 2004, this law was amended, and what it basically did was it added transition services, meaning that there had to be services provided for these students that will enable them to be as independent as possible as an adult. One of the terms we're going to be talking about today, and this is really the crux of the IDEA, is the term free appropriate public education, also known as FAPE. And what it is, it's the right to special education related services and the right to be educated in the least restrictive environment. I'll be going through all of these. Even though there may be more than one appropriate educational placement for a child, there's only one environment that's considered the least restrictive. The placement is known as the learning environment for your child. Under the IDEA, an individualized education plan team, or IEP team, has to consider placing the student in regular education first, with modifications and accommodations. Only if the student can't be appropriately educated in a general education classroom do we go toward what are considered more restrictive placements. Those are from getting a special education teacher in the classroom, so in-class resource, to pull-out resource replacement programs, which is a separate class for certain subjects, a self-contained class, meaning a separate class for all subjects, a New Jersey approved private school for students with disabilities that the school district would pay for, a non-approved but accredited private school for students with disabilities, and then you go on to the most restrictive placements, which are residential schools, or the most restrictive of them all, home instruction, where a student is educated at home by a special education teacher. Now, how does this process begin? A lot of parents, it's so difficult. This is a complicated area of law. There's lots of issues going on. So it's often confusing about how you actually start the process. So it starts with this simple legal term, child find. Child find is the affirmative obligation of a school district to seek out and evaluate students suspected of having disabilities in all areas of suspected disability. This is an affirmative obligation on the school district, which means that the school district should be actively seeking out these students. So who qualifies as these types of student under child find? It has to be a student between the age of 3 and 21. If it's before age 3, early intervention services provided by the state are utilized. The student needs to be diagnosed with a disability. The disability must adversely affect educational performance. One of the important things to note is that educational performance does not just mean academics, and a student is not required to fail. The student also needs to be in need of special education and related services. Special education counts as specialized instruction. Related services are things like speech, occupational therapy or OT, physical therapy, PT, counseling, etc. Now, who can start this process? It can be any member of the school staff, including teachers or the child study team. It could be parents. It could be any outside agency concerned with the welfare of the child. As a parent, if you think your child needs to be evaluated for special education and related services, the easiest way to go about it is to send a letter or email to your school district's director of special services to explain the issues that are going on and then ask that they be evaluated. The school district has 20 days to respond under the law. So what would happen next is there would be an evaluation planning meeting. It would be certain school staff members that have worked with the child. It would be members of the child study team, which are individuals that will test the child. Could include a speech language pathologist. And the district decides at that point if there's enough information to move forward. If they do, then they will seek the parent consent, and the parent has to consent to evaluate the child. The school district, under their child find obligation, must test in all areas of suspected disability, and they have to use at least 2 different assessments. They have 90 days to complete this initial evaluation. It can be 90 calendar days. It's not 90 business days. They need to provide copies of the reports of those evaluations within 10 days of what's called the eligibility conference, the next stage in the process. Evaluations can take on many different forms. Most common are the psychological evaluation, which is usually an IQ test and certain behavior assessments, an educational evaluation, which measures a student's academic abilities in certain subjects such as math, reading, writing, study skills, that sort of thing. Speech language evaluations are another type of evaluation. Functional behavior assessments are conducted by a board certified behavior analyst to determine a student's behaviors in the classroom. As part of the evaluation process, the school staff has to observe the student in the classroom as part of their evaluation. So once these reports are provided, the parent and the school district then meet for what's called an eligibility conference. An eligibility conference is where the parents and the school district review the outcome of the evaluations, and the school district then makes a determination if the student is eligible for special education and related services. If that's the case, most of the time at that point, the school district will then immediately transition into an IEP meeting to develop an IEP. In order to be eligible for special education, as we discussed, it's a 3-prong test. And if all 3 prongs are met, then the child has to be eligible. In New Jersey, there are 14, and actually with the federal law too, there are 14 categories that you can classify a student under. It's not what drives the type of services needed. So if you meet the criteria for special education for one of these things, the district is obligated to educate the whole child, meaning all of their areas of need. The 14 categories that are in the New Jersey Administrative Code, and every single state has these 14 categories. They may be worded a little bit differently, but this is what they are. They are auditorily impaired, autism, intellectual disability, communication impaired, emotional regulation impairment, which is primarily psychiatric diagnoses, multiple disabilities, which is when you have 2 or more disabling conditions that cannot be separated, deaf/blindness, orthopedically impaired, other health impaired, which ADHD or something like Tourette syndrome or related disorder could meet the criteria under OHI. Then there's preschool disabled, which is only for preschool students, social maladjustment, which is also another behavioral one, is not used that much in New Jersey, specific learning disability, traumatic brain injury, and visually impaired. I wanted to go into specific learning disability a little bit because this one is often misunderstood as how to characterize. So a specific learning disability is a perceptual impairment that involves a disorder in psychological processes, which centers on using language. It could be either spoken or written. and it affects the student's ability to listen, think, speak, read, or write, and it often happens within a specific academic area. In determining if a child meets the criteria for a specific learning disability, there are a couple ways of doing it. One is called a severe discrepancy formula, and school districts are allowed to choose if they use this formula or not, which is basically a discrepancy between the student's IQ and what they're achieving in a certain subject. The severe discrepancy formula typically is if there's a 22.5 point discrepancy between a student's IQ and what they're achieving in an academic subject on the child's study team evaluations. So as a hypothetical, if a student had a 100 full-scale IQ, which is an average IQ, but scored a 75 in reading, then they meet the criteria for a specific learning disability in reading. There is criticism about this method because students may struggle much more than what their educational achievement scores signify, and certain tests tend to test students' strengths more than their disabilities. So there's a lot of debate over if school districts should continue to use it. You can also look at a student's functional ability in the classroom in those subjects to help determine if there is a learning disability. So if a student is found eligible for special education, a school district will then develop an individualized education program, or IEP. The IEP is the blueprint or roadmap for special education. It is the most important document within the IDEA. It sets forth what a local educational agency or school district will do for the child. An IEP has to cover a lot of different things, and I'm going to go through each one of them. So it needs to address and work on the child's academic and functional needs, and also, and this is very critical, non-academic needs, and they could be behavioral, social, emotional, life skills, activities of daily living. It needs to address both the academic and functional needs. One of the other things to note is that the IDEA requires that every student's IEP shall be accessible to each teacher, meaning regular education teacher, special education teacher, related services providers, and other individuals that work with the student. Now, it's important to note that even though they have to be accessible, the law does not mandate the IEPs be distributed. So if you have a concern that the IEP is not being read by teachers, make sure you contact that teacher or your child's case manager that implements the IEP and let them know to share it. I personally think that it should be part of the law that it's distributed to all staff working with the student, but that's the way the law is, and with attorneys, we have to follow what the law says. So the IEP, in addition to addressing the student's academic and functional needs, it's supposed to detail any accommodations that the student should be receiving in the classroom, as well as how do we measure this child's achievement and functional performance on standardized assessments to see if they're making progress. Now, in addition to these criteria, IEPs now need to contain transition services and transition needs listed in the IEP. That can start as early as age 14, but it has to start no later than age 16. The IEP is supposed to signify what the school district will be providing for the child, not what the child is going to do. So we oftentimes see in IEPs it says students will do this, students will ask for this. But if a student doesn't have the skills yet to be able to ask for that help, you need to specify in the IEP how the help is going to be brought to that student to teach them the skills needed to become more independent. It also needs to include behaviors as well. So if there are behavioral needs of the child, then a behavior intervention plan needs to be created. That is the product of a functional behavior assessment, and that will be formalized into the IEP. The IEP also needs to include the strengths of the student, and I'm going to explain why in a few minutes. But as I said, the school district needs to educate the whole child in all of their academic, developmental, and functional needs, and that also means helping them utilize their strengths to overcome their weaknesses. In addition to students that have behavioral needs, their communication needs need to be addressed, as well as if they need assistive technology services. Assistive technology can take on a wide variety of different forms. It can be utilizing a laptop instead of handwriting. For certain students, it could be utilizing some sort of picture software to help them speak, or some sort of iPad app that'll enable them to make their needs and wants known if they're nonverbal. If these things are essential to helping the student access their education, then the school district needs to provide it, and that's done on an individualized analysis. One of the other aspects of an IEP that needs to be provided is what's called the present levels of academic achievement and functional performance, or as we attorneys call it, the PLAF with a silent P. So what a PLAF does is it has to describe what the child's disability is, how it impacts their ability to access the general education curriculum, and how it impacts their ability to participate in activities. Looking at the PLAF, you should be able to get a snapshot as to what the child's strengths and weaknesses are and what their needs are. The PLAF is very important because it influences the next part of the IEP, annual goals. IEPs must contain goals that are academic and functional for the student's areas of need. That could be, for example, math, reading goals, could be behavioral goals, it could be emotional regulation goals, it could be spoken language goals. In New Jersey, under the administrative code, and also for other IEPs as well, the goals are annual. That means that it's the student's expected level of achievement, not making progress on the goals, but achievement for every one school year. So the IEP goals should be drafted in a way that the student should be expected to achieve that goal within one school year. And the goals are also to talk about how the goal is going to be met, as well as what the criteria is for mastery of the goal. So it may be something like 90% success after 5 attempts or something like that. And that's just as an example, but there's a wide variety of different ways to measure progress. IEP goals also need to cover short-term objectives, and short-term objectives are basically benchmarks for the IEP goals. Could be 3 or 4 of them, could be more, as to how the student is going to achieve the goal in totality. So, I mean, overall, you know, a student, if you're seeing that IEP goals are not met at all each year, even if it says they are progressing on them, that may be a sign that the IEP goal either might not be appropriately written or might be too high a skill at that point for the student if it doesn't seem to be achievable. So if IEP goals are repeated year after year, that generally is a problem. So the next thing I wanted to talk about are IEP meetings in general. IEP meetings can happen for many different reasons. An IEP is what's called a living, breathing document. That means that changes can be requested or made at any time, so long as both parties agree. So at an IEP meeting, for whatever the reason it's called for, including your first IEP meeting after the eligibility meeting, the parent needs to be provided with a copy of the IEP or written notes setting forth what was agreed to and determined by the IEP team. The parents are equal and full members of the IEP team as well. If an agreement cannot be reached between the parties, the child study team still has to develop an IEP as the local educational agency. One of the questions I'm often asked is, does a parent have to provide consent for the IEP to be implemented? The answer, unfortunately, is it depends. So if it's your first ever IEP, the parent has to sign it in order for it to go into effect. Now, for any subsequent IEPs, it depends on if it's a draft or a final IEP. If it's a draft IEP, it's not going to necessarily go into effect. If it's a final proposed IEP, that means that IEP can go into effect after 15 calendar days, whether the parent signs it or not. So one of the most upsetting parts of a consultation is if a parent comes to us saying, we disagree with the IEP, it's taking away a service, and they hand us the IEP to review, and we say, when did you get this IEP? 30 days ago. We have to unfortunately tell them, unfortunately, there's nothing we can do, because unless you file for mediation or due process within 15 calendar days of receiving that IEP is going to go into effect whether you sign it or not. And I'll talk a little bit more about those processes in a little bit. So the 15-day notice is so crucial for parents when they get an IEP. As I said before, placement, that's also part of an IEP, and that is the educational learning environment for the child. And I talked about what are the different things that can be part of an education placement. So it can be, in-class resource, it could be a resource classroom where the student is pulled out, it could be a private school for special education. There's a wide variety of different placements. In general, as a tip after IEP meetings, save your child's IEP and all your IEP progress reports each year, because if you're seeing on the progress reports that the child is not making progress on certain goals, and then you see in next IEPs that the goals are repeating, that's an issue. The other thing is, even though IEPs can be amended at any time, IEPs have to be reviewed at least once a year on the anniversary, generally around then of when the student got their first IEP. This is called the annual review meeting. It doesn't matter if you're in a legal dispute with the school district, the annual review meeting always has to occur. The next topic I wanted to discuss are reevaluations. So when a student is found eligible for special education, it's not something that lasts forever, although many parents may want it to last forever. So every 3 years, it's called a triennial reevaluation. Every 3 years at maximum, a school district needs to reevaluate the student to see if they still qualify for special education. While a parent has the right to waive a reevaluation, in certain circumstances, it's not always a good idea to do so, because then you're operating with an IEP based off of outdated data of the student. So if you're a high school student and you haven't had this student evaluated since they were 5, then you don't really have an accurate picture of where their functioning is, or what, even if their IQ is accurate. So it is good to get updated data. Now, if a student is having a change in circumstances, meaning they may have a new diagnosis, new issues come up, you can move up reevaluations. It's just that at a maximum, it has to be every 3 years. The types of evaluations, you'll have an evaluation planning meeting again and an eligibility meeting. When it's a reevaluation, school districts have 60 calendar days, not 90 to complete them. The next concept I want to discuss is FAPE, Free Appropriate Public Education. FAPE is what is basically a successful IEP. A successful IEP provides a free, appropriate public education. Appropriate is the key word. So what is FAPE, and will we know it when we see it? So I'm going to go through a little bit about what FAPE means for a student. It starts with a Supreme Court decision a couple decades ago called Rowley, and it says that the child needs to be able to meet the basic floor of opportunity. They need to have personalized instruction with support services to enable a child to benefit educationally from that instruction. That's the basis for the legal interpretation and precedence, but it doesn't really get at what those things are. We understand that, what type of benefit are we expecting from the child? What is the level of benefit? The Rowley Court didn't answer those questions. So in New Jersey, FAPE is something that's provided at public expense under the supervision of a school district that it should be meeting the state's educational standards, which are in the New Jersey Administrative Code. And educational standards are individual for each child with an IEP. The school district needs to comply with the IEP. Implementation integrity is often an issue where an IEP may say something. You may have the greatest IEP in the world on paper, but if half the services aren't being provided on a regular basis, that's not an appropriate IEP. The IEP needs to be individually tailored for the student's unique needs. Now, in New Jersey and around the country, education is a broad concept. It's a lot more than academics. It's communication, social, emotional, daily living skills. It could even include toileting. It's whatever a child needs to learn to be as independent as possible as an adult, to the extent that they're able to. Now, New Jersey is part of the Third Circuit, which is a federal court region. It includes New Jersey and Pennsylvania, Delaware, and Maryland. There's a case called Ridgewood v. NE, and it goes a bit further than the Rowley Court, and it describes FAPE as significant learning and meaningful educational benefit. Going on, the Third Circuit also ruled that it needs to be more than a trivial educational benefit, and it needs to be significant. So it needs to be something you not only can see, but you can read, that is noticeable, the child's progress. It's not just simply making a tiny amount of progress. Another aspect of the Ridgewood decision is that the level of progress for a child needs to consider the intellectual potential and cognitive ability of the student. The educational benefit has to be related to that child's potential. So what we describe it as is a child needs to make progress commensurate with their ability, meaning cognitive ability. So in the case of Ridgewood, when a student displays considerable intellectual potential, otherwise known as a twice exceptional student, the IDEA requires a great deal more than a negligible benefit. So let's say the student, for example, progresses in reading from a 5th grade level to a 5.5 grade level in one school year. But this student's IQ signifies that they should be achieving above grade level, and this student is in, let's say, 7th grade. That's not meaningful progress for that student. But if that student has a severe intellectual disability, severe dyslexia, and other types of issues, that half year's growth in one school year may be appropriate for that particular student. It's a very individualized analysis. None of these court opinions are considered blanket rulings, but they give us a roadmap as to interpret if a student is making appropriate progress or not. Now, unfortunately, this is actual language from the New Jersey Supreme Court, in that school districts must provide the educational equivalent of a serviceable Chevy to every handicapped student or student with a disability. They're not entitled to the Cadillac of education. It's a ridiculous analogy, but again, as lawyers, we have to go by it because that's what the courts say. The latest special education ruling that sets forth a national standard is the Andrew decision from the U.S. Supreme Court. The most important aspect of it is that it holds that IEPs need to be appropriately ambitious in light of the child's circumstances. So it's not only that the child is making progress, it's that they need to have the opportunity to meet challenging goals and objectives for that student. So that takes the Ridgewood case, even though it's not a Supreme Court case, it's a bit similar to that. New Jersey has always had a standard that's similar to the Andrew decision, but this provides more direction for that. And again, it has to be more than a trivial benefit. The IEP is not a performance contract, so even if a student does not achieve every goal, that doesn't mean the IEP is inappropriate. If a student is achieving a lot of their goals, that may be enough for that student. If a student passes from grade to grade, that's important to consider, but that does not always mean that FAPE is provided. Let's talk now about what a 504 plan is. This is the other major law for special education. A 504 plan is a plan of modifications and accommodations. It's not specialized instruction. It's designed to prevent discrimination for students with a disability, and it's designed to provide them an equal opportunity. The goal is really to level the playing field. The criteria for having a 504 plan is that a student needs to have a physical or mental impairment which substantially limits one or more major life activities, that the disability has been around. It's not just simply that just appeared, and the student is regarded as having such an impairment. The important thing to note is that it's not about it's about the degree as to how impaired the student is, not necessarily the diagnosis itself. What are major life activities? It includes everything from walking, seeing, hearing, concentrating, reading, working, caring for oneself, learning. So there's a lot. A lot of times school districts have mistakenly said that we can't give a 504 plan to a student because their disability is not affecting their learning. But ultimately, being able to attend school, thinking, concentrating, communicating, speaking, all of these things impact a student's ability to succeed in school. So if a disability is not affecting, quote, learning, but it affects these other things, since a school is a place of accommodation, public accommodation, that student needs a 504 plan or would potentially qualify for one. What counts as a substantial limitation? Oftentimes you look at the duration of the impairment. Does it impact a major life activity? Again, it doesn't have to be learning. It's just a major life activity. Does it result in failure or underachievement when compared with their non-disabled peers? And will the impairment disappear without any intervention from the school? So, for example, if a student has, Lyme disease and they have it for 2 weeks and the antibiotics get rid of it without any intervention from school, you can't necessarily get a 504 plan for that. But let's say, for example, the Lyme disease lasts a couple months, then you may be able to get a 504 plan. One of the things to note is that children are getting long COVID from the pandemic. Long COVID does count as a disabling condition for 504 plans or an IEP. Other health impaired is the category. The U.S. Department of Education made that very clear a couple months ago. So if, God forbid, your child is suffering from long COVID, that is a qualification criteria for a 504 plan or an IEP. Now, what are some examples of accommodations? They can be changing the way homework assignments are done, a test is given, different types of instructions about assignments, getting copies of notes, verbal instructions with visual cues, different behavioral management techniques. It can also, in some cases, include things like speech therapy, occupational therapy, counseling from a school counselor. There's so many different things that can be done. One of the misnomers is that a 504 plan is not as strong as an IEP and that it's viewed as a consolation prize. That's not the case. The Department of Education has said that 504 has a wider scope of coverage than the IDEA because the IDEA only provides IEPs when a student needs specialized instruction. But this is a way to get the student help for a wider variety of different conditions. And anything that's in a 504 can be part of an IEP in terms of the accommodations and modifications that can be done. Not everything in an IEP can be provided within a 504 plan, but the 504 plan has a wider variety of what can qualify for it, which may be able to get some students help that they otherwise would not be entitled to. The next thing I want to talk about is what happens if there's a dispute between the parent and the school district. So these are called procedural safeguards for parents. At the end of every IEP or 504 meeting, a school district needs to provide the parent a procedural safeguards notice, which in New Jersey is that little booklet you always get, or in my case, I'm a human version of that. But it basically sets forth the parent rights. So if you haven't read it, definitely read it. The parent has a right to obtain independent educational evaluations if they disagree with the school district evaluations. In some cases, that is helpful because the school district would need to pay for those evaluations, but you don't always have control over who those evaluators are. And school districts, if they refuse those evaluations, have to file for due process against the parent. it makes it more adversarial, but that's what the law says. The parent has the right to consent prior to evaluations and to IEPs, and to have access to their child's educational records. There are a number of different ways to dispute, to have a resolution for a dispute. They can happen at any point in the process. It could be you're disputing a type of service being given. It could be a service not given. It could be the type of educational placement your child's in. It could even be whether the child is qualified for an IEP or 504 at all. All of these things apply. One of the newer resolution processes is called a resolution session. We generally don't do them. It's basically a meeting between the parent and the school district prior to initiating litigation. Ultimately, it's, sometimes it's helpful, but it's often the two parties meeting with each other and they've already said no to each other already. Mediation is a great way to potentially resolve a dispute. You meet with a state-appointed mediator, and the mediator will work with the parties to try to resolve the dispute. And the parties can get very creative. The mediators in general are great. We know all of them, and they try really hard to resolve disputes because these are about kids that have significant needs, and they know that a long, drawn-out litigation process is very difficult. In many cases, and we as attorneys agree, a settled case is a better case, because even though you may not get everything you want, if you have some control over the outcome and certainty over what's going to happen, it's often a big relief, and it usually results in tremendous benefit. If a mediator helps resolve a dispute, the mediator will create a mediation agreement, and it has the same force of law as if a judge ordered it. Now, when you file for mediation or due process, parents can do that online or use an advocate or attorney to file for it. It triggers a 30-day resolution period, 30, and that basically is a mandatory time to try to resolve the dispute where you can meet for mediation or resolution session. If after 30 days or mediation or a resolution session fails, then within 1 to 3 weeks, typically, you meet with a settlement judge for a settlement conference. And at that point, if a judge can't help you resolve the dispute, then it goes to a different judge for an actual trial, not with a jury, but with expert witnesses, parents, school district employees, and then a judge decides ultimately what the outcome is going to be. And typically it's all or nothing, or it's in the judge's discretion. So as part of preparing for due process, meaning filing it, it's important to review all the student's records, determine if there's a need for experts to come in or educational consultants to do evaluations, observe the student in school, etc. So just a couple points. Just always remember, for parents, you are a full and equal member of your child's IEP team. You have the right to be provided information about your child in terms of what they're doing in school, what progress they're making, that you have the right to ensure your written permission is given before evaluations begin, that you get prior notice of any changes in the program. And that you have the right to the records. Under child's find, parents have the right to a complete evaluation of their child, which means all areas of suspected disability, and also the right to confidentiality for student records. Now, for college, your special education records do not travel with you, but if you want to get accommodations in college, and that's a whole nother topic to discuss at a different time if needed, then you would need to disclose these records. Parents are often worried about, will this negatively affect my child's chances of getting admitted to a college? What I often say is that it's not going to negatively affect it. It's either not going to affect it at all, or it may actually help, because colleges often want to see a student triumphing over adversity or how they use their skills to confront difficulty, getting through high school, succeeding in school despite your areas of need is often looked upon very favorably. And as we know, students with either learning disabilities, learning differences, or disabilities, if they get the right support, can go on and do great things in life. You have the right to FAPE for your child, requesting independent evaluations if you disagree with the school district evaluations. You also have the right to obtain your own private evaluators to evaluate your child, that you would need to pay for them, but they also have the right to observe your child in school. Parents also have the right to observe a district's proposed classroom for your child before you consent to the IEP. Transportation is a related service. So if your child getting to school is an issue, then that's part of the IEP as well, or 504 plan if applicable. Now for COVID, it's a little bit different now because most schools are not doing hybrid or virtual learning, although with some case increases, some school districts are doing some virtual learning. Each district has their own plan to do so. The obligation to provide FAPE remains. The Department of Education never waived the school district's responsibility for this. So if a school district says, well, everyone was suffering under COVID, so that's just what happened, FAPE still needs to be provided. Now, obviously, school districts, it's not like they couldn't do anything for a while. They actually couldn't because of certain laws in place. So if a child has regressed during COVID, during the pandemic shutdown, compensatory education services can be discussed to help bring the child back to where they were and then making progress again. It's an individualized analysis. Some children may not need it. Some children may need some may need a lot. Now, before we go to question and answer, I just wanted to give a few general tips in terms of what I've seen in practice and just for parents to know in general. For IEP meetings or 504 meetings, go into there knowing what you want and what your child needs. It's often helpful to send a letter or email to the team in advance of an IEP or 504 meeting to help understand what your concerns are and what specifically you think would be helpful to discuss. One of the most important things is don't be adversarial with the school district staff. And the same thing goes for the school district staff to the parents. Many times we have to get involved because there's a breakdown in trust between both sides. And being adversarial at these meetings doesn't help. That's not to say you shouldn't be afraid to disagree or even vehemently disagree, but you could do it in a way that's not yelling and screaming and pounding the table. It just doesn't work. And it doesn't help in any way to help with your child's position. So obviously, share your concerns, but generally it's better even when you disagree to keep it cordial and professional. It also, mediators and judges like that. And the law calls for cooperation to the maximum extent possible between parents and school districts. Don't be afraid to share information about your child, whether it be, they're having issues at home that are related to school, or, they're seeing a new therapist and you want them to collaborate. These are the sort of things that are helpful because if there is a dispute later on, it's helpful to know that, for the parent side that they're being cooperative, or for the school district side that you asked for that information. Again, the timeline, when you get a new IEP, not your initial IEP, and it says final on it, you have 15 days to file for mediation or due process to invoke stay put. Otherwise, that IEP will go into effect whether you sign it or not. Stay put is an automatic injunction. That means the IEP or 504 plan change is automatically stopped. The school district is forbidden from implementing it unless the dispute is resolved, a judge decides it, or the parties jointly agree or settle the case. But stay put goes on for as long as the dispute goes on. That's designed as a special mechanism for protection of the child. If, as a parent, you see certain concerns, but the school district isn't necessarily agreeing or not necessarily seeing it, it may make sense to get a private person involved in the case. It could be someone that's currently treating your child. It could be an educational consultant. It could be a neuropsychologist, speech pathologist. There are so many different types of evaluators. But as a parent, you have a right to have that private evaluator observe your child in school and test them. And that may be very important because it may uncover information that the school district didn't know about or help provide more information. And then that can often show, what is going on to a much greater detail. And just in general, it's so important to know your rights. You can be much more confident in these meetings if you know generally, and there's so many different parts of this law, but if you have a general idea of what needs to be provided for your child and that you've researched, you've done your homework, and it allows you to be able to talk with confidence with the school district staff, and the school district too needs to know their own rights as well to help facilitate a meeting. So at this point, I think I hit the time exactly. I would be more than happy to answer any questions you may have.
Sorry about that. So we have a lot of questions, so I'm going to jump right in here. The time reference for responding to referral requests, testing results, etc., that you referenced at your very beginning of your, are those different for each state that you know of?
They might be. I can't speak with full authority outside New Jersey, but in general, that is something that I have heard. So in New Jersey, a school district has 20 days to respond to a demand to evaluate, or it could even be a demand for a change in a program. If after 20 days, or there's no response at all, or if they respond no within those 20 days, then the parent has an automatic dispute with the school district. Sometimes school districts may not respond at all after 20 days. So if after 20 days happen and you don't hear anything, that's interpreted as a no under the law.
Are schools at risk of violating HIPAA if they share IEP or 504 docs to employees of the school who may interact with the student?
No, that would not be a violation of HIPAA because IEPs contain certain information about the child. They're developed by the school district, so they are to make it accessible to any staff member that may need it.
Okay. If a child has a disability like Tourette syndrome, but the child study team determines the child does not need an IEP, what can a parent do?
There's a couple different options, and it's different for every child. One is the child may qualify for a 504 plan, which is a plan of accommodations. Those accommodations can be anything from counseling to, if they're having an increase in symptoms, to be able to leave the classroom at any time, to go somewhere to cool off, or to address that. There may be medication breaks that are needed. But if a parent believes that an IEP is what's needed and the evidence supports that, then at that point they can file for mediation or due process, because not providing eligibility is a dispute with the school district under either the IDEA or 504.
Okay. Is a functional behavior assessment required to be done if they have an IEP, or is it optional or only if requested?
FBAs, and it depends, FBAs or functional behavior assessments don't have to be done. It's if there's a behavioral need, if a student is struggling behaviorally, then it should be done. So not every student is going to have it. It's not always necessary for each student, but if a student is having behaviors that are happening on a regular basis, then that could potentially trigger the need for an FBA.
And this one, I'm going to put in the blog. Is there a way that you can look up special education attorneys in other states? Is there I don't know, is there an organization or something along those lines?
There is. There's a group called Council of Parent Attorneys and Advocates, or COPA, and they have a listing of attorneys that specialize in this in every state.
Great. Thank you. If a student is granted an IEP, do they automatically qualify for a 504?
Yes, the answer is for that, yes. Any IEP is basically a 504 plan within it, plus specialized instruction and related services. But if you have a 504, it doesn't necessarily mean you qualify for an IEP. anything in an IEP can be added to a 504 plan. Let me put it this way. Let me step that back for a second. Any accommodations in an IEP, meaning accommodations and modifications, can be part of a 504 plan.
All right. Can something be added to protect a child that has an IEP against bullying?
Absolutely. There's special alerts, which are on the front page of the IEP. There's accommodations, modifications, strategies, especially if a student is having certain peer difficulties. But under the harassment, intimidation, and bullying law, or HIB, if a student is being bullied for being a member of a particular class, meaning that, it could be religious, it could be ethnic, it could be a disability. Students with disabilities, if they're being bullied for their disability, that counts as harassment, intimidation, bullying, and they are entitled to protections. The other thing to keep in mind is that if you are a student with an IEP or 504 plan, a student cannot be disciplined traditionally if the behavior or action is a manifestation of their disability. That doesn't mean there can't be consequences, but the consequences have to be tailored to help with that student's disability. So, if a student, called someone a name and they may not have meant it, or it was impulsive, or they couldn't control it at all, that may be a manifestation of their disability. So it wouldn't be a traditional punishment. It would be, what are the services that are needed to help this student so this doesn't happen in the future? And so when it's a manifestation of the disability, it's not necessarily on their on a behavior record, although those records don't always travel to college anyway. So it is an important measure of protection. So if your child is disciplined, and, for example, is suspended or expelled or something like that, you can request a manifestation determination, and the school district should be doing it anyway to determine if it's a manifestation of their disability.
Okay. Your firm helped us with another webinar earlier on HIV law, so we can always refer you back to that as well. How is long COVID defined to determine disability?
So it's not necessarily, what it is. It's basically if the student has a diagnosis of it and if it's adversely affecting their educational performance. So if they're lethargic in school, if they're not actually able to get to school due to the illness, it's just like with any other disability. If it's adversely affecting their educational performance, and do they require specialized instruction and related services to be able to have an appropriate education? So, they may have decreased physical strength, so they may need occupational therapy or physical therapy. That could be something. So it's just like any other disability, and that's the most important thing. And that it's now like school districts, if that's the reason they have to provide an IEP, that is an exactly permissible reason.
You spoke about having that they have to have the IEP is supposed to be made available to all school personnel. Does that extend to substitute teachers?
Yes, absolutely.
Even though substitute teachers aren't technically school personnel?
They are employees of the school district, so and they are working with that student. So, for example, a special education class teacher may be absent, so they may need a substitute teacher. That's a class of all IEPs. So that teacher would need to know. If it's a general education class and students have IEPs with certain accommodations or certain specialized instruction, it still needs to be provided whether there's a substitute or not. So IEPs are designed to be implemented, by all staff in terms of what it says. So, substitute teacher would definitely need to have that accessible.
If there are more questions, please go ahead and put them in the question box. We'd love to have them. We had some sent prior to the webinar, so let me check them. See if we've gone over them. People are very thankful for enlightening the public on these things. They're important. Yep.
My pleasure. It's really important to know, especially in this time with the pandemic, because these are the types of students that are being affected the most by it and need the most help in order to get back on track.
So if a parent feels like the 504 or the IEP isn't being adhered to or met, their options are what?
So their options are they can challenge it on their own by filing for mediation or due process, but if they don't have an idea of how the process works, it's going to put them at a disadvantage, because when you file for mediation or due process, the school district is always going to bring their attorney, whether or not you have one or not. So that's something to keep in mind. You can get an attorney to help you with this. Sometimes certain treating professionals can help. You can bring anyone you want to an IEP meeting that has knowledge of your child, or you can even bring family members for moral support or friends. So you can bring other people to IEP meetings to help you with your position. But if there is a dispute, then it's best to do your research, talk to someone who's knowledgeable about the process. And also, I forgot if I put it up there or not, but I'm available to anyone in the presentation if you have a question, something personal that you wanted to contact me directly about. So I am inputting my office phone number, and it's also on the last slide of the presentation. And my, actually, I don't know if I sent it correctly, but my phone number to be reached at work is 609-409-3500. And my email address is andrew@sgwlawfirm.com. And you're more than welcome to reach out. Or you can also reach out on the blog forum that's going to be available for the rest of the week and part of next week. And I'll be posting on there some information potentially and answering additional questions on there as well.
Okay, if a child is not awarded an IEP, when can a parent ask for retesting? The next school year?
It depends. Again, if a parent disagrees with the results of the evaluation, or the parent doesn't think that they were comprehensive enough, at that point in time, you should request either an independent evaluation. If a school district agrees, they will pay for it. If they disagree, they are going to have to file due process against the parent. At any time, the parent can get a private evaluation and then provide information. Whenever there's new information sent to the school district is legally obligated to consider it. They're not bound to agree to it, but they have to consider it. So, if you want the child study team to reevaluate again, there isn't a specific set time frame, but just to let you know, if it's within the same school year, the school district cannot repeat the same exact tests. So they have to use different assessments. Otherwise, there's something called the practice effect, which means a student may do better because they've seen this type of test before.
Okay. Can they bring someone to an IEP eligibility meeting?
Absolutely. You can bring, for any type of IEP meeting, you can bring anyone you want that has knowledge of your child. And it can range from a family friend to some sort of medical or treatment provider, all the way to an attorney.
Okay. Somebody asked,
and if you don't feel one more thing. If you don't feel comfortable going to an IEP meeting by yourself and you feel more confident if someone's with you, bring someone. You're always allowed to do that.
Absolutely. Another set of ears that's not quite as attached is usually a good thing.
Definitely.
Can you share the name of the Association to Search for Attorneys in Other States again, please?
Sure. It's called COPA, the Council of Parent Attorneys and Advocates.
Okay, great. Well, that looks like our questions for this evening, and I'm sure that there are more, and you can always go out to our blog on our website. That's found under our main screen under programs, webinar, blog, and archive, and the blog should be open now and available for the next 7 days. I appreciate everyone coming tonight, and I hope that you have a great holiday season. Bye now.
Thank you so much. Have a great holiday.